Good afternoon and welcome to session 6 of the risk management and insurance component of the PMT course. Just going to pull my presentation up. My profuse apologies for that. The stuttering technology. So I will pull my presentation up once again. In this session, we will deal with with the Legal Practitioners Indemnity Insurance Fund, the Lpiif, and then to do with the Legal Practitioners Fidelity Fund, the commonly known as the Fidelity Fund. What is the Lpiif? The Lpiif is a short-term insurance company which was established by the Fidelity Fund in 1993. The company was previously known as the Attorneys Insurance Indemnity Fund, the AIF. That's why in some of the documentation you still have reference to the AIF. The name of the company was changed after the Legal Practice Act came into effect, because it now does not only indemnify attorneys, but it also indemnifies trust account advocates. Thus the change of name. This is the company is the insurance vehicle through which the professional indemnity insurance and the bonds of security, which are referred to in Section 77 of the Legal Practice Act, are provided. It is a non-profit company. Currently, it is funded by way of a single premium that's paid by the Fidelity Fund on behalf of all insured legal practitioners. If there is a change to the funding model, that will be communicated to the legal practitioners. And it's important to note that the Lpiif is independent of the other structures in the legal profession and the insurance industry. The reason I stress that point is because often people phone us and they say that they want to notify a claim under the law society insurance. There is no law society insurance, and this company is not owned by the law societies or the Legal Practice Council. Or they contact us and say that they want to notify the company that their claims to the insurance company that was owned by one of the insurance brokers. This company has never been owned by any of the insurance brokers. It was previously managed by the insurance brokers, but it has never been owned by them. So please remember that the company is independent. What does the Lpiif do? Provides effectively 3 services. The first is the professional indemnity insurance to attorneys and trust account advocates. Secondly, it provides bonds of security in favor of the Master of the High Court to attorneys who are appointed as executors of deceased estates. And secondly, it's the risk management services to the legal profession. And the risk management services include training, as we are doing today, as well as the publication of risk management material in the Rebus and Risk Alert Bulletin and the Risk Alert Bulletin. We also undertake litigation for certain test cases where that affect the liability of attorneys or the risks faced by attorneys. Just a few comments on the executor bond service, because I haven't covered that in the presentation because it's not really relevant for present purposes. But that is a free service. The bonds of security are granted up to the value of 5 million per estate, or a total exposure of 20 million per firm at any one time, please log on to the Lpiif website. There is a page for executive bonds, and you'll get the details there. If you require risk management training for yourself and your staff, please send an email to the risk.queries@lpiif email address, and we will provide the training to you. Even that training is provided at no cost. It doesn't matter where you are in South Africa or how big or how small your firm is. The training can be provided. We can provide training on the risks in general, but if you want training on a specific area, whether it be maybe if you for example run a mainly conveyancing firm and you want training specifically on conveyancing, we can do that. And the Lpiif services, as I've mentioned before, are provided at no cost, and you can get more information on the company from its website, www.lpiif.co.za. We'll focus on the professional indemnity insurance, and think that you will recall that diagram from session 5. So our focus today is on the primary layer, the bottom part. We'll start with looking at what the Lpiif covers. I've often, throughout the various sessions, referred to professional indemnity claims. So the terms of the insurance cover are set out in the master policy, and you can obtain a copy of the master policy either from your manual, or you can get it off the Lpiif website. When I refer to the manual, I refer to the notes that you've received as part of your pack for the PMT. It's one policy that's issued that applies to all legal practitioners. It indemnifies the insured legal practitioners against professional legal liability. So professional indemnity claims, in other words, to pay compensation. And the payment of compensation, please underline that, because you'll note from when we deal with the exclusions that various other claims, for example, an order against a firm to pay costs, their bonus properties, that is not compensation, and thus it's not covered. So it's to pay compensation to any third party. Any third party is also important, because it's not only to your client who will suffer losses if you fail to carry out your duties properly. Could be other parties as well who would be able to sue you in law. The requirements are that the claim must arise out of the provision of legal services by the insured, and secondly, that the claim is first made against the insured. So if the claim against you doesn't arise out of legal services that you provide, but arises out of some other business you are running, that is not covered. Or if it just lies against you in your personal capacity outside of law, that won't be covered. And that the claim must be made against you. It's what is referred to in insurance parlance as a claims made policy. So a claim is made against the insured by sending a letter of demand or instituting action against them. Either of those is enough to trigger the cover under the Lpiif policy. Legal services are defined in the policy in clause 20. That's a Roman numeral 20. It's just sorry to digress. all the clause numbers that I'll refer to, whether it's Roman numerals, those are the definitions in the policy. We number them using the Roman numerals. So legal services are defined as work reasonably done or advice given in the ordinary course of carrying on the business of a legal practice in the Republic of South Africa in accordance with Section 33 of the Legal Practice Act. Work done or advice given on the law applicable in jurisdictions other than the Republic of South Africa or are specifically excluded unless provided by a person admitted to practice in the applicable jurisdiction. It simply means that the company covers work that's reasonably done in the course of carrying out legal services in South Africa. If, for example, you decided that as part of your legal practice you will run an estate agency or property devaluation or auctioneers, those are not legal services and will thus not be covered by the policy. And because you are admitted to practice in South Africa, will cover you for work that you do in respect of South African law. If you carry out the law of any other jurisdiction, the policy will only cover you if you are also admitted in that jurisdiction. And a claim, as I've indicated, is a written demand for compensation from the insured, and it must also arise out of your provision of legal services. And for purposes of this policy, a written demand is any written communication or legal document that either makes a demand or intimates or implies an intention to demand compensation or damages from the insured. There's a common misconception is that summons needs to be issued against the insured. That's not the case. The letter of demand is sufficient to trigger cover. And who is insured? You can have a look at clauses Roman numeral 16, clause 5, and clause 6 of the policy to see who is insured. But in summary, it's every sole practitioner, partnership, or incorporated legal practice that is covered, as well as trust account advocates. And in order to fall within the definition of the insured, each partner, the director, or the sole practitioner, or the trust account advocate must have a Fidelity Fund certificate at the time that the cause of action, and the cause of action will be the circumstance, act, or omission giving rise to the claim. So when the error which gave rise to the claim occurred, the question is whether the party concerned had a Fidelity Fund certificate. The Fidelity Fund certificate is effectively your key to get into the policy. And the Lpiif cannot cover anybody else except those groups of practitioners. So if you run your practice as a company or as a trust or any other legal format, it won't be covered. And the fact that the cover in terms of that's provided by this company is only to be provided to a close group of individuals and entities is set out in the case referred to there, Propel Specialized Finance versus Attorneys Insurance Indemnity Fund. The Supreme Court of Appeal confirmed that in the judgment that was handed down on the 28th of September 2018. Remember that in session 6, I said that if you want to see the differences between the Lpiif and commercial insurers, you can look at the judgment of the Court of Appeal in that matter, the judgment of the Western Cape High Court. The amount of cover that's provided by the Lpiif includes the current partners or directors of the legal practice, provided once again that they had a Fidelity Fund certificate on the date that the cause of action arose. Previous partners or directors who had Fidelity Fund certificates on the date of the cause, on the date that the cause of action arose. I apologize for the typing error there. But what this means is that if you have two directors in a firm, and the one director was dealing with a matter which prescribes, and that director leaves the practice, and after the director has left the practice, the client institutes action against the firm, even if the director, the former director, has left, as long as on the date that, just for an easy example, on the date that the claim prescribed, they had a Fidelity Fund certificate, and then they are covered. The employees of the legal practice are also covered under the firm's limit of indemnity, as well as the estates of the people referred to above. So if in the unfortunate event that an attorney or trust account advocate passes away, and there's an action pending against them, a professional indemnity claim against them, the estate of that person, the executor will report the claim to the Lpiif, and the Lpiif will provide the cover. Liquidators and trustees are only covered where their appointment is motivated solely because they are legal practitioners, and the fees derived from their appointment is paid directly to the legal practice. You'll appreciate that it's not only attorneys that can be appointed as liquidators or trustees, it's almost anybody. And we had a situation where some law firms run insolvency practices but do not run it through their law firms. They run it through a separate entity, and the fees are paid to that entity. In those cases, the legal practitioners consent will not be covered, because the fees are earned by another entity. And if the appointment is not motivated solely because you are an attorney, you'll also not be covered. And looking at the amount of cover provided by the Lpiif, it's an annual amount of cover, and it's determined by the number of partners or directors in the practice on the date that the cause of action arose. You can see a recurring theme here. The date that the cause of action arose is very, very important. So people who are publicly held out as partners or directors will also be considered as directors for purposes of the policy. This is true to address a situation where some firms unfortunately embark on a practice of bulking up, where in order to make themselves look bigger than they are and to attract clients, they list people on their letterheads as directors who are not directors. So when the Lpiif considers your claim, those people who are publicly held out as directors will be considered as directors. Remember that the insurance year runs from 1 July of each year to 30 June of the following year. And it's important to note that the amount of cover is an annual aggregated amount. So I like to say to legal practitioners, it's an amount that's put in the basket for you for the year, and that is for the entire firm. Is covered under that one basket of money. It's not an amount of cover that's afforded per claim. In the top-up market, insurance cover is not given on an annual amount, so you don't get 1.5 million rands per year in the top-up market. You get maybe 1.5 million per claim, if that is what the cover you've agreed with your insurer on. And it's also not given per partner. often get calls from firms where each partner wants their own limit of indemnity, and that is not the case. It's important that those misconceptions are addressed. So, what is the amount of cover? It's it's on a sliding scale. So, sole practitioners, and by sole practitioners, it also include the advocates with the Fidelity Fund, trust account advocates. They are treated as sole practitioners as well, so they get that amount, 156,500 per annum, and so it goes up. The top tier is the firms with 14 and above partners. They get the 3,125 million per annum. And the excess that's payable is also determined by the number of partners in the firm. If you look at column B, it's for claims in general. And then column A is a higher. You'll note that the excess is higher because this relates to high-risk areas, prescribed RAF and conveyancing. And then with prescribed RAF matters, if the matter is not registered on the prescription alert system, an extra 20% is added onto that amount in column A. And then the other point there, that the reference to clause 20 of the policy. This is these are claims arising out of dishonesty. So where the claim arises out of the circumstances where the legal practitioner has witnessed or purportedly witnessed the signing or execution of the document without seeing the actual signing, or making it a representation which is false, you will be charged the higher excess as well. You'll appreciate that certain types of reckless or dishonest behavior need to be punished, and the higher excess does that. When in the respect of the slides that I've just covered, please read the resources that we have listed there: the December 2020 Risk Alert Bulletin, March 2021, and November 2020. They will assist you in understanding who is insured, how much you are insured for, as well as in understanding the excess payable. So the exclusions from the Lpiif policy are listed in clause 16 of the policy. I've just summarized them. Please read the full wording in the policy itself. The first one is trading debts. So for example, if you don't pay rent and your landlord sues you, if you haven't paid rent for your firm and your landlord sues you, that's a trading debt. In the same way that if a client sues you for a refund of fees because they say that you've overcharged them, that's a trading debt. It's and thus excluded. Misappropriation or unauthorized borrowing of trust monies, excluded. Please have a look at that article in the March 2029 Risk Alert Bulletin. As well, the next exclusion is risks that are or could more appropriately be insured under another policy. For example, a misappropriation of trust fund policy, personal injury, commercial, or cybercrime insurance policy. So those risks are better suited to be covered in another policy, and a prudent legal practitioner would ensure that they have those policies in place. Judgments from foreign courts, and the reason for this is, first of all, South African legal practitioners shouldn't be providing legal services in those foreign jurisdictions to where they are not admitted. And secondly, the judgments from the foreign courts, the basis of liability is different to South Africa. in on the North American continent, for example, the quantums are very, very high, and yes, it would be a huge risk to cover those. If you provide investment advice, not covered. Next exclusion is investments other than investments in a section 86.4 account. Fines, penalties, punitive or exemplary damages, or orders to pay cost step bonus progress are also excluded. We'll appreciate that those are not orders to pay compensation. Work done in respect of the National Housing Program provided for in the Housing Act. Bridging finance related claims are also excluded, except for the three circumstances that are listed there. If the bridging finance was applied for to pay transfer duty and costs, municipal or other rates or levies payable in respect of the property which is the subject of the transfer. Those three categories are really those are expenses that need to be paid in order to receive clearance certificates and for the conveyancing transaction to go on. A big part of the bridging finance problem we had is that parties were bridging the sale, the sales of their properties and not using that money for what it was intended, and rather using it for either paying other debts or going on holiday or even purchasing motor vehicles. But as I've said before, because the conveyancer signed the undertaking, the conveyancer was then held liable. So unqualified undertakings that are dependent on the act or omission of a third party will also be excluded. From time to time in legal practice, you need to give undertakings, but if the fulfillment of the undertaking is dependent on a third party, the Lpiif will not cover you. And if it's a breach of contract other than a professional duty, the example I've given will also apply here, that if you breach your lease agreement in respect of a practice and do not pay your landlord the rental when it's due, then and your landlord institutes action against you, that's not a breach of a professional duty. Another example, which is also common, is that the legal practice may engage outside experts, such as the medical legal experts, and not pay them, and then the experts institute action against the practice. That's not covered. You did not owe a professional duty to those experts. You're just in a business relationship with them. Acting as a business rescue practitioner is also excluded, because a business rescue practitioner becomes effectively an officer of the company that's under business rescue. Receipt or payment of funds that are unrelated to a specific instruction. This is where the legal practitioner acts as a mere conduit for funds or as a paymaster. If the receipt of those funds is totally unrelated to an instruction to actually carry out legal services, it will not be covered. Claims arising from defamation are similarly excluded. And then cybercrime, we've spent a significant amount of time in session 4 dealing with cybercrime. But I would like you to pay special attention to the definition of cybercrime in the Lpiif policy, clause Roman numeral 9, the definition of verified, that's included in clause 16.0, and the examples of excluded claims that are set out in that clause. You'll see that that clause refers to bridging, business email compromised claims as well, though it doesn't use those words. And when you're dealing with the cybercrime exclusion, also consider clause 16C. Just to help remind you, I'm going to go back. Clause 16C, risks which are or could more appropriately be insured under another policy. And then the other exclusions are claims by related entities. So if the legal practitioner, for example, owns a business for which they also do the legal work, and they get something wrong in carrying out the instructions for that business, and the business institutes action against the firm, you may think it's far-fetched. It happens where people are effectively suing themselves wearing different hats. Those are excluded. Acts of war-related activities, nuclear activities, asbestos, those that are excluded, and then legal services provided in violation of the Act. So that it effectively is a summary of clause 16, but also see the exclusion of fraudulent applications for indemnity in clause 17, and the exclusions in clause 18 for dishonesty, fraudulent, or the criminal acts. The claims procedure. First thing you do is to give immediate notice to the LPIF of any circumstance that may give rise to a claim. So if you are dealing with a matter and you realize that you've made a mistake, or somebody in your firm made a mistake, report the matter to the LPIF. If the plaintiff takes no further action, then it's all in well for all concerned. But it's prudent to give the insurer notice, because it may be a matter that can be corrected, and that instead of going through the process of dealing with the claim, the insurer may decide to pay for the corrective action, then that will avoid a claim. Notify the LPIF in writing no later than 1 week after you receive a written demand. That's a letter of demand, a summons, a counterclaim, or an application. Sometimes you may have instituted action against your client to recover fees, and they institute a counterclaim against you, saying that you did not carry out the services properly. Report that to the LPIF. Or you see that the client has brought an application, whether it's against you or whether it's against someone else, but the allegations seem to be casting aspersions on how you handle their matter, and making allegations of negligence on your part, or some other breach of your duty of care or your mandate. Report those to the LPIF. I think that as a general principle, it's prudent to rather err on the side of caution and report things to the insurer, even if you feel that there is no merit in the complaints, and that nothing will come of them. You'll also be required to complete the risk management self-assessment questionnaire. A copy is also in your manual, and it's good practice to complete it in any case, because it will focus your mind on risk management issues. And I would suggest to you that over and above doing the assignment at the end of this module, just in order to test how well you've grasped the concepts, please complete that risk management self-assessment questionnaire. You'll also need to complete a claim form. Importantly, do not cede or assign your rights in terms of the policy. Do not admit or deny liability. Don't settle a claim. Don't incur costs unless it falls within your access. And the prohibition of of session was confirmed in the Propel specialized finance cases. What should you do when you're faced with a possible claim? 1, do not make any admissions. You'll then be conflicted, so recommend to your client that he or she consult with another legal practitioner. Notify the Lpiif in terms of the policy, the clauses, the relevant clauses I've referred to on the previous slide. And if you have top-up insurance, simultaneously notify your insurance broker. Retain your full file of papers that will be required for purposes of your defense. And if the client requires a copy of the file, please give it to them. Prepare a detailed background report for your insurer, including a report on the alleged breach of the mandate, the error, the omission, the breach of fiduciary duty. Cooperate with your insurer and its agents. Including the legal team that the insurer will appoint to run your defense. Remember that if you don't provide your cooperation, the insurer may very well withdraw indemnity. I've included a link to the Lpiif website for the claims procedure. The first one is for legal practitioners. The second one is for what you need to know if you're acting for a claimant. And if acting for a claimant, remember that your claim lies against the insured legal practitioner, not against the Lpiif. The Lpiif policy does not give any rights to third parties. Only only an insured can notify a claim and apply for indemnity. You'll please have a look at the article I've referred to the end of August 2018 edition of the Risk Alert Bulletin. Also see clause 39 of the policy. Clause 39 says that this policy does not give third parties any rights against the insurer. The test for liability has been set out in a number of cases. You please have a look at the authorities that are cited in footnotes 21 and 22 of your manual. Effectively the test will be whether your conduct met the standard expected of a reasonable attorney in the circumstances. Moving on to the Fidelity Fund. The Fidelity Fund is a client protection fund. It indemnifies the person who suffered the loss as a result of the theft of the trust funds and not the legal practice. We often get calls at the office where people say, oh, my bookkeeper has stolen money. How do I go about claiming it from the fund? No, you do not claim it from the fund. The fund is not there to indemnify you as the lawyer for the losses. It indemnifies the owner of the money. It's a fund of last resort, which means that the client will need to first institute action against the defaulting attorney. That's the attorney who has either stolen the money, or if it's a member of the staff of that attorney, the firm will still be vicariously liable. The client will first institute action against them. They will exhaust all their legal remedies against that defaulting attorney. Exhausting legal remedies means they have to go the whole hog, so so to speak, attaching the whatever assets there are, and only if then the claim remains unsatisfied, and then the client will be able to go to the fund. The fund may, in its discretion, waive the requirements for the excursion. And an easy example would be if an attorney has stolen money from 10 clients, and the first and the second client go through the process of exhausting the rights and attaching everything that the attorney owns. Doesn't make sense to then ask all the other clients who are in the queue to go through the same process that has already been carried out. The liability and claim procedure are set out in Chapter 6 of the Legal Practice Act. Please read it. It will also assist you for purposes of the assignment. And you can also get the claim procedures that are on the Fidelity Fund website. I've included a link there. And thank you very much. That is the end of session 6. We will meet again in the final session, which is session 7.